Department of Business University. In advance, I would like to thank himself for trusting me to help guide this event. Then also to the Business Law Department of Business University as the organizer of this event. Presumable with this 10th anniversary, Business Law Business University will become more advanced and produce perspective like experts who can have a great influence on Indonesia in the future. First of all, I would like to introduce myself. My name is Kalisa Dia. I am a second-year student at Business Law Business University who will help guide the event as an MC. Before I start, I would like to remind the entire audience to turn off their microphone and maintain order during this webinar. To open today's event, we will start with opening remarks. First one, we would like to invite Dr. Ahmad Sofian, SHMA, as head of Business Law Department at Business University to give some speech. Mr. Ahmad Sofian, the floor is yours.
Yeah, thank you very much. Yeah, speakers for Adrian Bettner, Professor of Law and Society of Indonesia at KIT Alvi, Director van Vollenhoven Institute, Leiden Law School, the Netherlands, and Prof. Mark Kamek, Professor of Law, Southwestern Law School, Los Angeles, USA, Prof. Kibet von Benda Beckman, Professor Emeritus and former head of the study Gulf Legal Pluralism at the Max Planck Institute for Social Anthropology, Germany. Moderator, Mrs. Vidya Parasita, Lecturer of Business Law, Business University, participants, members of Business Law, Des Natalis Committee, College at the Business Law. The first, I warmly welcome you all at the 10th anniversary of the Business Law Department. In this international webinar, we are proud to present you three speakers who have extraordinary level of knowledge in the field of empirical approach to the law, the topic we will discuss today. The Business Law Department is moving towards the age of 10 years old, a relatively young age compared to other law faculties in Indonesia and the global level. However, even though we are still young, we have the means to produce qualified alumni and scientific works by lecturers of national and international reputation. This event was the idea of Dr. Stijn van Heus, a permanent lecturer at Business Law, Business University, with a PhD from Leiden, the Netherlands. Dr. Stijn will provide a brief background on why this theme was brought up in international webinar. I think this is all can I say. Welcome and congratulations on joining this international webinar at Business Law Business University. Thank you.
Thank you, Mr. Ahmad Sofian, for the speech. And for the second opening remarks, we would like to invite Dr. Stijn van Heus as the project officer for the international webinar to give some speech. Dr. Stijn, the floor is yours.
Thank you, Pak Sofian, for your nice remarks. Dear guests to this international webinar, it really is an honor for us at Business Law Business University to welcome our distinguished guests at the celebration of our 10th Dies Natalis. Our speakers today are affiliated to universities from 3 different countries. Professor Adrian Bettner, director of the Van Vollenhoven Institute Leiden Law School in the Netherlands. Mark Kamek is professor at the Southwestern Law School, Los Angeles in the United States of America. And Professor Kebet von Benda Beckman works at the Max Planck Institute for Social Anthropology in Halle, Germany. Our speakers work in 3 different countries, but have 2 things in common. And the first is their affinity with Indonesia. They all love Indonesia. And 2, There are non-doctrinal, socio-legal, and legal anthropological approaches to the law. Yeah, the second point brings me to the topic of today's webinar, which is the relevance of empirical legal research to legal practice and legal policy. Worldwide, the number of publications concerning non-doctrinal empirical approaches to law is growing. There's an increasing number of journals specializing in social legal studies, law and society, legal anthropology, and now also empirical legal studies and law and economy. An increasing number of law faculty also offer courses, streamings, or even masters on these subjects. But at the same time, it's also true that the legal curricula at law faculties, and then especially at the bachelor levels, continue to be dominated by doctrinal and dogmatic approaches to the law. Apparently, these are the skills that graduates are considered to must have first and foremost have acquired. Sorry. Now, this observation brought us as panel conveners to the topic of today's webinar. So what would be the reasons for law students to engage with empirical approaches to the law, social legal studies, legal anthropology, law and economics, etc.? What relevance do legal empirical approaches to law have for graduates when they, in their future careers, will become legal practitioners or will otherwise be involved in jobs that concern issues in the area of legal policy? Once again, I must say it's a privilege for us at BINUS to host three distinguished and experienced professors on this topic, and we are all very excited that they are willing to share their thoughts and experience with us. So thank you all. Selamat berdiskusi dan terima kasih juga kepada semua peserta yang telah bergabung pada acara malam ini.
Thank you, Mrs. Stein, for the speech. And before we start to the main event, I would like to introduce the moderator for today's event, namely Mrs. Vidya Prahasacita. She is a faculty member, lecturer, and content specialist at BINUS University. She graduated top of her class in the Master of Law program of University of Indonesia, majoring in criminal law and criminal justice system, who has experience in litigation, corporate, and intellectual property practice. She is keen on conducting research on actual cases and analyzing those using collaborative doctrines and theories which are relevant in practice, as reflected in her thesis and final paper. She also contributes to society by handling pro bono cases and teaching university students. Henceforth, I will submit this webinar forum to the webinar, namely Mrs. Vidya Prahasacita, SHMH.
Thank you, Kalista, the Master of Ceremony. Hello, ladies and gentlemen. Welcome to the international webinar, The Relevance of Empirical Legal Research to Legal Practice and Legal Policy. It is an honor for me, Vidya Prahasacita, to be your moderator for this event. I would like to say thank you for the Business Law Department at Bina Nusantara University to organize this event, the panelists who provide their time, and to more than 400 participants who registered and attend this evening event, both in Zoom and our YouTube channel. Now in Jakarta is around 8:30 p.m. In Netherlands and in Germany around 3:30 p.m. In Los Angeles is around 6 a.m. So it's good morning, good afternoon, and good evening to all. Thanks to the technology, we can meet all together for this different place around the world, from US, Europe, and Asia, Indonesia, and a couple places in Indonesia. Some of participants, not only in Jakarta, but also from Bali, from Sumatra, and other islands in Indonesia. Before we begin the webinar, the moderator would like to announce several things. First, during the webinar, the organizer will mute the participant microphone. During the webinar, the organizer will share attendance list and the panelist material link in the chat room. During the panelist presentation, the participants can write their question in the chat room. You can write in Indonesia or you can write in Bahasa, because our speaker can, because our panelists can speak Bahasa Indonesia well. So the organizer will choose the participants' questions and the participant can deliver the question directly to the panelists. But when you ask the questions, please turn off your camera so we can see your face while you're asking question to the panelists. Okay, let's begin the webinar. For most Indonesian legal scholar, we know about document legal research, or some of us well known as normative research. But how about empirical legal research? I myself know better this subject when I enroll my PhD program. Okay, we will discuss about this topic. Now at your screen, we already have three great panelists. First, Professor Adrian Berner. Second, Professor Mark Kamek. And last and not least, Professor Kebet von Benda Beckman. I hope I pronounce your name correctly. I'm sorry if I wrong pronounced it. Okay, first session is Professor Adrian Berner, who would like to present his paper with title Legal Differentiation of Judging in a Void, Impossible for Justice Without Empirical Knowledge. I will read Professor Adrian Berner's short CV. Professor Adrian Berner is KATLV Professor at Law and Society in Indonesia and Head of Department of the Van Vollenhoven Institute of Law, Governance and Society. Professor Adrian research has focused on access to justice, legal reasoning, family law, and land law, in particularly in Indonesia. This lead to publication on wide variety of subjects, ranging for administrative court and environmental litigation to human rights promotion, in marriage law regime and Indonesia legal education. Professor Adrian has been involved in many research and legal education projects in Indonesia, sponsored among other by the Royal Dutch Academy of Science, the Dutch Research Council, the Dutch Department of Foreign Affairs, and NUFFIC. He is the chairman of the board of the International Institute of Asia Study, editor of Rothlight book series Law, Development and Globalization, and a member of a working group on legal cooperation Indonesia and Netherlands. Before Professor Adrian Berner present his paper, I would like to ask you some question. Apa kabar, Pak?
Halo.
Halo. Apa kabar?
Pertanyaan apa? Ya, apa kabar? Baik. Jadi pada akhirnya cuacanya baik di Belanda, jadi merasa seperti di Indonesia sekarang.
Kapan terakhir ke Indonesia, Pak?
Ya, itu sudah 1 tahun lebih karena keadaan COVID, tapi mudah-mudahan insya Allah bulan Oktober bisa ke Indonesia lagi. Jadi mudah-mudahan ke Binus juga. Oke.
Pak, kalau Bapak datang ke Binus, kita sediakan makanan apa yang Bapak paling kangen?
Wah, itu soto ayam aja.
Oke, nanti ingat ya panitia, kita pesenin soto ayam buat Professor Adrian Berner. Oke, Professor, time and floor for you. Thank you.
Yeah. Thank you very much. Can I share my screen? But this is because in my presentation I have some animation, so it would be good if I can share my screen myself. If that's possible, that would be really nice. Thank you very much. Yeah, I think it works. Yeah, there we go. Okay, so first of all, thank you very much for having me invited to discuss this really important topic, which I've been working on for a long time, as the debate in Indonesia concerning the place of empirical legal studies, or more generally, the place of social sciences in the study of law, is a topic that pops up all the time. And that keeps being discussed. And if I can contribute to that discussion, I'm always really happy. So the title of my presentation is Legal Differentiation or Judging in a Void, the Impossibility of Justice Without Empirical Knowledge. And what I mean to say here, just for a start, is to say that law in any case is related to reality. You're dealing with real people, you're dealing with real cases. You always need to look for facts as a judge. Students also need to learn that it's important what the facts are, even before you can think about starting to apply law. And then the way in which you construct the law, it will always be informed about notions which are not solely limited to legal science, but which originate from different fields, and where it's important to take into account how people within other fields of the humanities and the social sciences have dealt with them. Now, this might sound rather complex, but let me start with a case in the Netherlands, which I think brings out very clearly what the issue is. And this is a big affair in the Netherlands. It's called the allowance affair. On the picture, you can see people demonstrating. Yes, we have demonstrations too in the Netherlands. We have demonstrations against the government. We have demonstrations also against legal policies. And in this case, you can see the banner which says unknown injustice, justice now. So these people are asking for justice. What was the case about? What are they asking? The allowance affair concerned a program by the Dutch government, which provided an allowance to people for daycare. So people who are working and who need to bring their children to daycare can get an allowance in the Netherlands. You needed to apply for that, and if the conditions were all fulfilled, then you could get your allowance. This was executed by the tax department, so you needed to, together with your tax application, you needed to also submit a request for childcare allowance. This went completely wrong because the law that was made said that no matter how small the mistake someone had made in applying for this childcare, if there was one small detail which was not complete, then one would have to pay back all the money received. And this meant that if you had made a mistake of 10 euros, so there was a form missing, or a receipt was missing, of only 10 euros, you might have to pay back 30,000 euros. So the result of this was, and sometimes the mistake was not even made by the people themselves applying, but the mistake was made by the center providing the daycare. So you can imagine that this went completely wrong, and that in the end, really tens of thousands of people ended up indebted and actually could not move along in their lives anymore for many years, because they had to pay back this childcare, where in principle they had been completely entitled to. The government in the Netherlands fell because of this issue. It was in the end brought to light by a number of journalists, as well as by members of parliament, who addressed the government very critically on the issue. And now, after everybody agreed that this was horrible, what had happened, and that this has gone completely wrong, people start to think, where did it go wrong? And the conclusion was it went wrong everywhere. It went wrong with the politicians who made the law. It went wrong with the government, which didn't supervise the implementing agencies well. It went wrong with the agencies, but it also went wrong with the judge. Because the lawyers of people who had to pay back this money had actually addressed the judge and asked to be given back, basically saying that they were entitled to the money and that they should be allowed to keep it. And the judge had dismissed this because the judge argued that he could not test the case against the proportionality principle. He could not apply the proportionality principle because the law said that no matter what, the judge was not allowed to test proportionality. That was basically the argument. So the judge applied a very logistic argument, a very formalist argument, looking at the law and say, okay, the law says this, so I can't move at all anymore. This is the end of it. So this is what happened. I'll get back to the issue later and say more about what empirical knowledge has to do with it. But before that, I want to look at the next slide, which is about how we can explain such miscarriage of justice. And I think the main reason is that there is an expectation that by keeping out all empirical arguments and all empirical insights, that will lead to legal certainty. The idea that if you just look at the law and you just apply it, preferably in a literal way, will lead to certainty and to the ideal interpretation of the law, because people know what they're about to, they know what they can expect. When we look at it historically, we can see that this debate is quite old, and it's quite strange that it's actually still being that people still are concerned about these questions, because when we look at Germany, and perhaps some of you may recognize the gentleman on the left, this is Georg Puchta, who was one of the fathers in Germany of the so-called, what was derisively called the Begriffsjurisprudenz, which was a very dogmatic way of interpreting the law, a very grammatical way of interpreting law, basically not making any connection between the facts on the ground level and also not looking at developments, but just sticking to the letter of the law as it was. Now, clearly, already early in the late 19th century, criticisms arose. One of the best known is Rudolf von Jhering, the gentleman the picture is there, who said that law is serving a purpose, and you must always look at the purpose it wants to serve in interpreting the law. You can never just look at the text of the law and apply it straight to the facts. You always need to look at what the law's intention is and how you need to understand the facts in the light of the intention of the law. A similar argument was made by Eugen Ehrlich, who went a step further and said that you can only interpret the law in a just manner if you are aware of the living law, the norms people in daily life adhere to, the norms that govern a particular field, a social field, an organization or whatever. Now, this argument is actually quite close to what von Vollenhoven argued, and the name of von Vollenhoven perhaps will be more familiar to most of you than the name of Ehrlich, where von Vollenhoven said there is also living law. There is, in the case of Indonesia, that was adat law, and that this was a legal system which should be recognized and which we should take into account in all our dealings with issues of justice. So, actually, the whole idea, it's strange, therefore, that this debate still is so hotly contested in Indonesia. This idea, and I shared the book of Hans Kelsen, Teri Hukum Murni, but this, of course, this argument has been taken over, as you know, by a number of Indonesian doctrinal legal scholars who try to approach law in Indonesia the same way as Hans Kelsen, Puchta, and others promoted to do this in the 19th century in Germany, or the early 20th century. There's a very good critique of that way of thinking. It's called Kritiek terhadap Paradigma Positivisme Hukum. The book is much more nuanced than you may think, perhaps, when you look at the horrible picture on its cover and when you look at the title. It's actually a very refined critique of legal positivism, but it's certainly not saying that legal positivism should be completely thrown out. There are limitations and there are problems with legal positivism, but it's not that you should just behave as if anything goes and that you should just have what Weber called Kadi justice, so where the judge does things of what he personally thinks is fair, but that there are other ways in which you can integrate knowledge into legal reasoning in a way that will help you to achieve more just outcomes. Now, and then what I always find interesting in Indonesia as well is that unlike most Dutch students, Indonesia students are really advanced and lucky that they get to know the ideas of Gustav Radbruch about what you want to achieve when applying justice. So legal certainty is part of that, but it's also justice and it's also social purpose or public purpose. So there is the purpose Van Jering was talking about, it's the justice Ehrlich was talking about, and it's the legal certainty which Puchta was talking about. So you see, that this actually is a nice triangle. And if, and this is my argument, if you want to achieve not only legal certainty, but also social purpose and justice, you will need to find other ways than just this dry doctrinal grammar-like interpretation of law, which is promoted by some. So how then to achieve this balance? Well, the first is you need to use a variety of legal sources. You cannot only use the legislation. You also need to look at what other judges have said about particular issues. You need to look at doctrine, what I have jurists written about it. You also need to look actually at custom, what is customary in a particular area. So there are all these sorts of law which you, I hope those who are studying law have learned about, and certainly I hope that those who have finished studying law are aware that there are more legal sources than often used in Indonesia. There's a variety of methods of interpretation. There's not only grammatical interpretation, but also something like systematic interpretation, but also teleological interpretation, which goes back to the approach of Van Jering, and where you really look at the purpose of the law and the need to understand what the law tries to achieve. For this to work, what we need is a communication between legal actors. So judges, lawyers, university professors, legislators, government officials, they need to talk and they need to be in a constant dialogue to determine the ideas, the ideas about how laws should and could be interpreted. And I think this will lead to what I call differentiation, the opportunity to carefully look at a particular constellation of facts, to carefully assess that constellation of facts, also with knowledge, with enough background knowledge to be able to understand the situation on the ground, and then to also differentiate in the application of your legal sources to be able to achieve justice, legal certainty, and purpose. Now, this is a picture which tries to show you the ideal situation of communication going on. I won't go through each line, but you can see here there is the legislator who produces laws, the judge will apply the law in putusan, but it's important that the putusan then will also be looked at by legislators again, so that they follow what's happening with the interpretation given to the laws they made by the court. You also see that there is people in universities here involved, there is doctrine involved, there are lawyers involved. So you see all these, you can make this picture way more complex still. But the problem is that instead of being more complex in Indonesia, it's more limited. And we see that many of these lines actually are not in place because communication within the legal system in many ways falls short of the requirements of achieving justice, social purpose, and legal certainty. And there, I think, is the main problem. Now, going back to the allowance affair, what is interesting here is that the judge actually has, as they say in Indonesia, done introspection. So unlike the lawmakers and unlike the government, the judge has been quite self-critical. And there is a few lessons which can be learned from what the judges did wrong. And the first is that they should have taken the principle of proportionality seriously. So basically, you can never allow the lawmaker to just set aside the principle of proportionality just like that, as in this particular case. You should always look at proportionality, like you should always be looking at equality, whether the law is equal, actually. So there are certain basic principles of law which you should take into account. Now, in order to be able to assess proportionality, you need to know something about the facts. You need to know, for instance, in the case of the allowance affair, if it had been single individual citizens, you could still have claimed that it was fraud. But when it became clear that there were tens of thousands of people who actually became a victim of this situation, then you know it can't be a matter of fraud anymore. This was really something more serious going on, and there was something seriously wrong with the system. And then you should assess the principle of proportionality in the light of this empirical knowledge which you have gained by looking at what people have studied about this, social scientists, but also just in newspapers by journalists. So you should take into account also the effects of a contested policy. So don't just look at the policy on paper. That was another conclusion of the judge. So you should really be, you should look at what does it do? As soon as you see that it's really, it brings people to basically to lose everything, to lose their home, to lose their income, to lose their job, to lose their children even in some cases, because they simply were indebted to that extent. Well, then you should be looking carefully as a judge and as a lawyer, as a jurist. So does it make sense what this law is doing, and can we still allow this law to operate in that manner? You should also take into account fundamental ideas about justice. Actually, what was behind this was an idea that the Dutch public was very angry about fraudulent behavior. So there was this story that many people were misusing the social security system. These were right-wing papers in particular who wrote about this, whereas in fact, there was no such issue here. So you should always check that. You should be careful, and you should look at the situation and also see whether indeed, if people know the facts in a particular case, whether they still have the same idea about what is just and what is unjust. And the fourth finding was that the judges said we should better consider the implications of our decisions. Now, where can you find all that kind of information? All that kind of information can be found in social legal studies. This is what social legal studies work on, and this is what I think is incredibly important for students and for lawyers in Indonesia to be aware of, to understand how policy works, to understand how policy implementation works, which will also help you to take a more relative view of what you are doing as a jurist, and to better understand indeed how important it is that you are careful in doing justice, basically. And as a final note, I want to add that the Van Vollenhoven Institute now has a Master in Law and Society, which was accredited last year. And one of the persons on the accreditation commission was a judge of the Supreme Court. And he told me that actually he's thought that our program was much more important for future judges than the master program in civil law, in business law. Sorry, Binus, but that is how it is. That's what he said, or administrative law, because students should be aware of the relations that the links that exist between law and society. I asked him whether I could quote him on this, and he said, yes, you can quote me on this. For those who know a little bit about Dutch history, this is a grandson of Eddie Duperron, who was a famous Dutch writer who was very much against colonialism and who also held who was close to people like the internationalists such as Shahir. So there is also a link to Indonesia here. But the most important thing is that I hope to have given you a little bit of an idea how I think that empirical knowledge and that the social sciences are important in doctrinal studies of law as well. That's it from me. Thank you very much.
Thank you, Professor Adrian. Very nice presentations and open our knowledge that our paradigm, especially in Indonesia, is more positivism. So more to Han Kelsen. So for law, we need more than a positive paradigm. We need, let's say, law is many things deal with real cases. So we have to see what the cases, and we have to we have to see law from different perspective, not only but based on what the law said, the legislation said. I hope my I hope my summary is still in line with you. Okay, thank you, Professor Adrian. Now the second panelist is Professor Mark Hamek with a paper titled "Law as the Prophecy of What the Court Will Do." Okay, short CV of Professor Mark Hamek is Professor of Law at Southwestern Law School, Los Angeles, United States of America. His interest in judiciary institutions and procedure form a common thread in all his scholarship. He has taught and written about the American jury and the procedural rules in U.S. criminal trial. His research on Indonesia has focused on the modernizations of the country Islamic judiciary and the effect of this institutional change on substantive law. Professor Mark has also participated in several collaborative studies that have used survey data to evaluate the impact of state family law policy on underage marriage, divorce, and contraceptive use. Professor Mark is frequently called on his expertise on the Indonesian legal system. In 2002, he was chosen by United Nations to monitor the trial of Indonesian military, police, and civilian officials charged with human rights crime committed in East Timor following the vote of independence in 1999. He has served as an expert witness on matter related Indonesian law and is currently as affiliated faculty member at the Asian Law Center at the University of Washington, where he advised a PhD student writing about Indonesia. Good morning, I think, Professor Mark.
Good morning.
Apa kabar?
Ya, baik-baik.
Professor, satu pertanyaan dari saya. Why you chose Indonesia as your focus or main studies?
There's no really good answer to that, except that I happened to come to Indonesia, and I think like the other panelists here, I just fell under its spell. And
yeah.
Once that happens, you just keep coming back, I think.
Okay, because the food, because the culture?
Well, definitely, I think there's not any single thing, but certainly the food is attractive.
Okay. Okay, Professor, without further ado, floor is yours.
Thank you, and thank you for the invitation. I have a very simple-minded PowerPoint here that I'm going to try to share. So I feel, does that display properly or? Okay. I have to confess, I feel like a bit of a fraud in this program. I have no training in empirical approaches to the study of law. I don't teach any classes related to empirical approaches to the study of law. It's true that I have done research in Indonesia that would be considered empirical. Much of that is because of my collaborator, who was the one who did most of the non-legal analysis of the issues. So I'm not really well qualified to talk about empirical methods. I also feel a little bit uncomfortable because I have a hard time simply understanding what it is we mean when we talk about non-empirical approaches to the study of law. I often hear Indonesians talk about doctrinal analysis and legal science, and honestly, I just don't understand what that is. For Americans, the question is not whether an empirical approach to the study of law is good or useful. That's not a question because there's simply no other way to do it. The only way to study law is by studying what actually happens when judges and other legal actors are doing law. That's the only way to study law because that's all there is. I'm going to just very briefly and in a sort of simple-minded way try to explain the understanding that an American lawyer would have towards these issues. And honestly, American lawyers don't really think about it. If you asked an American lawyer what her view is about the nature of law, she would probably say, I never really thought about it. American lawyers are nothing if not practical. Their goals are not to understand what the law is, but to win cases, which I'm sure is true of lawyers almost everywhere. But if they had to explain, or if they had to give some sort of philosophical explanation for the way Americans do law, it would be an explanation that is referred to in the US, and Indonesian students may well be aware of this as well. American law schools offer courses on what's called jurisprudence or the philosophy of law, but honestly, most students don't take it. I don't teach those courses. It's not something I know a lot about, and so I'm really out of my depth when I begin to talk about this. But the basic view of what law is that underlies what lawyers in America do is this statement by America's most famous judge, a man by the name of Oliver Wendell Holmes, who lived around the turn of the 20th century. That's not the last century, but the century before that. And what he said is that the prophecies of what the courts will do in fact, and nothing more pretentious, are what I mean by law. You can only study law empirically because that's all there is. Another often quoted statement by this same Oliver Wendell Holmes is that law is not a brooding omnipresence in the sky. There's not something out there called law that exists independently of what actually happens when, as I say, judges and other legal actors engage in activities that are considered to be legal. So the way I'm going to explain this general attitude, and as I say, it's somewhat simplistic or simple-minded, is that suppose you were an entomologist and you wanted to know everything there is to know about ants. And unfortunately, nobody else had studied it, so you couldn't just go to Wikipedia to find out the answer. There would be no other way to learn about ants other than going out in the world and finding some ants and examining them. So the first thing you might do is just figure out how ants are constructed. What are the various parts they have? You probably cut one in half, look at it under a microscope. It has these large eyes, these antennae that move in peculiar ways, the ability to detect smells out in the world. So how are ants constructed? But then even more importantly, more interestingly, at least with respect to ants, is you'd want to know what they do. And if you went out and watched the behavior of ants, you'd find that they cooperate in all sorts of really interesting ways. They collect food that they store. They build these large, complicated nests where they live together, and there's a division of labor. Some ants do some tasks, some ants do other tasks. So there's a sort of complicated social structure and social interaction. The point, though, is not what you would learn, but how you would learn it. There's nothing that you might think of as a sort of essence of ant, something that is the true character of an ant that exists independently of actual ants that are out there in the world. And if you want to know what ants are all about, there's no way to answer that question except go out and look. Well, as I say, that's also the attitude that Americans take toward law. Law is what judges do. How judges are constructed, how they're trained, what they think, what their politics are, and then what they actually do when they're presented with a dispute and have to make a decision. So when I finished law school, I had absolutely no training in social scientific methods. I was trained how to work as a lawyer, but I really didn't want to do that. And as I say, I had traveled to Indonesia, learned to speak Indonesian, and happened to have read a book that some of you may have encountered as well, written by the late Professor Dan Lev, in which he discussed the condition of the Islamic courts up through about the 1970s. And I had discovered that shortly after his book was published, a law had been passed in Indonesia that would necessarily result in significant changes, or the implication seemed to be that it changed the law that these courts were going to be called upon to apply. Prior to, this is a law that I'm sure you're all familiar with, the national marriage law passed in 1974. Prior to that time, judges who decided cases in Islamic courts simply applied the doctrines contained in classical works of Islamic jurisprudence, but following the enactment of the 1974 marriage law, they were obliged to apply the terms of that statute. So what I did, following my understanding that law is what courts do. Oh, first of all, as I say, I don't really have I have a hard time understanding how legal research can be anything but empirical, what there is to study other than law. But one way I do understand that is through another legal system or legal tradition that has a very clear and definite understanding of what law is, and does in fact believe that there is something called law that exists independently of society. For American lawyers to talk about the link between law and society just in some sense doesn't make any sense, because there's no difference. You can't separate law from society. Law is a part of society. It's a social practice. So to talk about law and society or law versus society just makes no sense. But within the Islamic legal tradition, it clearly does make sense. Again, I bring this up only to emphasize the contrast between the way the US legal system understands what law is and another view of law that views law as something different from what actually happens out in the world. And that, as I say, is Islamic law, which I'm sure all of you know enough about to know that under the understanding of law within Islam is that there is in fact a body of doctrines that exist independently of human action or human understanding of those documents. So within Islam, law clearly is not what the courts do. The courts seek to apply the law, but there's always risk, or some people's view certainty that they will not get it exactly right, but there is actually something that they should be applying. The question is whether they've done it. That's not the way Americans view law. For Americans, law is, as I say, what judges do. So when after having realized that research proposal that would likely attract the attention of funders would be a project that would go out and study how the Islamic courts in Indonesia were applying this new statute, I made the application, got the grant, and spent a year studying what Islamic courts do. And that involved trying to learn who the judges are that decide the cases. And it turned out that there were changes underway that hadn't been widely discussed that are now generally understood, but the courts were in the process of sort of reinventing themselves. Prior to the early 1980s, very, very few judges on Islamic courts had academic training. Most of them had studied in pesantren, but had never attended a university. Most of the judges were not civil servants. Of the three judges on the panel, typically the chair would be a regular full-time civil servant, but the other judges would be local ulama who had served on a part-time honorary basis under a new policy that was being implemented by the Department of Religion, but was not yet law. All judges had to have academic degrees, all had to be civil servants. And from the perspective of a legal realist, someone whose attitude is that law is judges and what they do, this makes a big difference. The way judges are trained will influence the way they understand the issues and the way they decide cases. And then the other thing that I did, which from my perspective was the most useful and in some ways the most difficult, was simply to try to find decisions. And in the mid 1980s, when I was doing to do, which for me was a great shock. The notion that the results, the judge's decisions would not be readily available was simply hard to understand, but they weren't. They're much more readily available now, although not as available as, in my view, they should be. But my research basically entailed collecting as many decisions as I could get my hands on in order to try to determine how judges actually resolve issues. What was the law as reflected in the decisions judges actually made? And as is almost always the case, in my view, you're going to learn something interesting if you go out and do that. American legal research is exactly that for the most part. We don't teach our students how to do empirical research if what that means is leaving the library or your office. What we teach them how to do is to find cases. And the American or the common law legal tradition has been collecting and publishing the decisions by courts for centuries, has developed extremely sophisticated methods of cataloging decisions, organizing them in terms of all sorts of different things. So in terms of the legal principles that are involved, in terms of the facts of the case. And so legal research involves finding and analyzing and comparing what courts actually do. And my own experience in Indonesia, both during my first research trip in the 1980s and subsequent trips, both subsequent research programs, both with the Islamic courts and the other courts, has confirmed my basic view that learning what courts do, collecting cases and analyzing the way judges actually resolve particular disputes provides enormous insight and is beneficial in all sorts of unanticipated ways. I'm not sure how long I've been speaking here, but I think I'll leave it at that.
Okay, thank you, Professor Mark. Actually, you still have 5 minutes to.
Well, so here's what we do. Here's what legal research consists of, and nobody would ever consider that to be empirical research in the U.S. But I think from the perspective of the Indonesian system, it would be. So I have written articles on topics unrelated to Indonesia. As was mentioned, I teach subjects related to criminal law and procedure. And in doing research on the US legal system, what I've done is collected and analyzed the cases that have addressed a particular issue. So for example, one of the articles involved the selection of lay jurors. There's a process by which the ordinary people who were called to serve on juries are culled prior to actually being seated on the jury. And that process often has the effect of removing from the group people from minority groups, particularly African Americans. And there's a complicated set of doctrines based on the US Constitution that governs this process. So I went out, collected all the cases I could find, decided by as many courts as I could locate addressing this particular issue, figured out how the rules actually apply in practice. And then there's inevitably a normative content to this kind of legal research, but that normative content is not guided by some notion of legal doctrine or legal science or principles that are inherently legal. The normative analysis is driven by, and this is sort of the presumption of this philosophical attitude toward law that's known as legal realism. The normative analysis is based on an analysis of the consequences that a particular rule will have and whether some particular consequence is socially desirable or not. And that can be informed by all sorts of different ideas, none of which have their source in the law. It can be informed by economic analysis. It can be informed by an analysis based on social justice. But the law itself can never answer the questions as to what the law should be, because there is nothing that there's no there, as we say. There is no law that answers the questions as to what the law should be. The only way to answer the questions as to what the law should be are to look to ideas about what kind of society we want to have, and how the law should be interpreted and applied in order to achieve those kinds of goals. I'll leave it there, I guess.
Okay, thank you, Professor Mark. It's interesting that law is part of society, as you mentioned. So judge, when they decide a case, not only use the material only in the book, but also have to see what law, living law, and how the law work in the society itself. So first, I a little bit terkejut juga gitu when I think, in my opinion, when you say common law system, I thought the jurists in New York and common law system learn the law not only in the book but practice in society, because common law has different how the bagaimana hukum itu dibuat terbentuk di common law system. But now when you explain, it's almost the same like in Indonesia, right? The jurists only see how the case, the jurisprudence case, but now we have to see law not just in the book, but law, how the law in the society itself. Okay, thank you, Professor Mark. It's very interesting. We have several questions, but hold on a second. We still have another panelist. The last but not least is Professor Kebet van Benda Beckman. The topic is what is legal practice. I will read Professor Kebet short CV. Professor Kebet van Benda Beckman is an associate of the Department of Law and Anthropology at the Max Planck Institute of Social Anthropology in Halle, Germany, and was formerly head of the project group Legal Pluralism at the same institute. She also an honorary professor of legal anthropology at the University of Leipzig, and a honorary professor of legal pluralism at the Martin Luther University, Halle-Wittenberg. She has carried out research in West Sumatra and on the Moluccas island of Ambon, and among Moluccas women in the Netherlands. She has published extensively on dispute resolution, social security in developing country, property and water rights, and decentralizations, and on the theory issue in the anthropology of law. She also co-editor of several books such as Specializing Law, Rules of Law, and Law of Ruling, on the governance of law, and political and legal transformations of an Indonesian polity. Professor, apa kabar, Professor Kebet? Hello, Professor.
Kabar baik.
Okay.
Terima kasih.
Terima kasih. Thank you for your time. But Professor, I interesting one thing about you. Why you choose Maluku as your research field?
Ada hubungan dengan Profesor Ohorella yang datang ke Leiden. Waktu itu saya bekerja di Leiden University, dan dia kepala adat di kampung dia di Ambon. Dia bilang datang ke Ambon dan untuk mempelajari hubungan di antara hukum negara dengan hukum adat dan hukum Islam. Jadi itulah.
Oke, menarik sekali ya, Prof. Very interesting. Okay, time and floor for you, Professor.
So thank you. Thank you for the invitation to participate in this webinar. I'm leading a rather nomadic life at the moment because I had to evacuate my apartment, and I'm halfway in the process of getting my apartment back in shape. I'm not staying at home at the moment. So bear with me that my contribution is a bit cursory. I would like to talk with you about the question, what is legal practice and where do we find legal practice? Usually, and we heard it in the past two presentations, it was mainly focused on courts and dispute management. But I think the legal practice is much more broad. You find it in trouble-free interaction. Law sets a context for people to interact and to negotiate. It defines legal relationships and status positions, allows people to enter into legal relationships, attaches specific consequences to interaction, for instance, to marriage, to making a testament, to rights, and it defines the rights and obligations that are that go along with these issues. It also clusters issues that otherwise have had to be dealt with individually. So, for instance, if you enter a marriage, it regulates a host of different things. And if you don't enter into a marriage, you can do the same thing, reach the same thing, but you have to make a lot of different kinds of contracts. It does so in contracts, in labor relations, in housing, in marriage, land transactions, inheritance, etc. So there's a whole, there's hardly any part of social life that is not somehow regulated by law. You also find it a legal practice in administrative interaction within the state administration, but also between state administration and clients. You find it in interaction in police activities. You find it in the process of legislation, making regulations, regulations about environment, about social security, about the relationships between legal orders, and so forth. And then finally, but only at the very end, you find it in dispute management, courts, village justice, arbitration, mediation, negotiation, and so forth. Now, much of dispute management turns around issues of evidence, of facts, and not so much about the interpretation of law. And it is in for the issues of evidence and of facts that socially empirical legal studies are particularly relevant. You might also consider legal education as one part of legal practice. Now, I think it's very important before we talk about how empirical legal studies can mean something for legal practice, to realize that legal practice has a different purpose than from the purpose of empirical legal studies. Legal practice is about deciding whether an act is legal, whether deciding any dispute, bringing the dispute to an end, making a piece of legislation, deciding whether something, a relationship or an act is correct, lawful, right, wrong, perhaps just or not. Making legislation that ideally fits the legal system as a whole. But the empirical legal studies ask, what do people do? Why? And what is the role of law in this? What is the social working of law? How does it affect the lives of people? The purpose is not to decide whether something is correct or lawful, but what people do. So these two purposes obviously require very different approaches. And to make it, to state it in a rather crude way, one could say that law operates through legal reasoning, through documents, aims at certainty and unequivocal outcomes, decisions, legislation, assignment of rights and obligations, etc. But it must be, ideally speaking, unequivocal. Social sciences operates through social theory, through observation, through interviews, questionnaires or participant observation. And here the possibility of ambiguity is at the core, I would say, of social sciences. They're not afraid of ambiguity, and they're not trying to do away with that either. Now, given this, these two different methods, it's clear that in order to get a rapprochement between the two kinds of knowledge production, there needs to be a process of translation. And the main problem, I think, in the question whether and to what extent empirical legal studies can contribute to legal practice is that insights derived from empirical studies that look at how people behave and why, and to translate that into insights that help legal decisions to be taken. The knowledge produced in empirical legal studies has to be translated into knowledge that can be used in legal practice. Now, obviously, the translation process is different for the different kinds of legal practice. For example, for the practice of legislation, it is of eminent importance to understand the social practice that needs to be regulated and see how and to what extent legislation is implemented at the very different levels of implementation. And Adriaan gave a clear example of the intricacies and the problems that are associated with implementation. For the practice of courts, empirical legal studies may help understand the social context in which a conflict occurs, to see whether courts may discriminate and how. And there are very interesting studies in the Netherlands about discrimination, not only of courts, but also of police and so forth. Empirical legal studies also may help understand how evidence is produced and evaluated. And here, especially the role of experts becomes very important, because experts usually that are asked for their expertise in courts usually come from a different background and are not lawyers, but are experts in social sciences or experts in all kinds of different sciences. For the practice of courts, it's also important to see whether court decisions are actually carried out. Mark mentioned that law is only in the court decisions, but is what the courts do. But what the courts do and what people do after a final decision may be something very different. And in my research in the 1970s in Minangkabau, in civil disputes, the majority of the decisions were not carried out in the way the courts had decided. either they were not implemented at all or they were implemented in a different way. And court decisions can be seen, as Mark Erlander once said, as a bargaining chip in further interaction. And this is not only a matter of Indonesia. In the 1980s, in a study in Rotterdam at the courts of first instance, also showed that most of the decisions were not, only 1/3 was implemented in the way the decision had said it, and the rest was either not implemented at all or implemented in a very different way. So social legal studies are helpful to understand what is happening with court decisions. Now, of course, legal interaction may involve, and in Indonesia it very often does involve, more than one legal system. There's a lot of research on the state's religion, customary, international and transnational law nexus, and Mark has said something about the position of Islamic courts in Indonesia, but there's a very interesting relationship between the civil state courts and religious courts, where at least in Minangkabau that we studied in 2000, between 2000 and 2009. The same goes for legal interaction in international arbitration and mediation and negotiation. And at the Max Planck Institute, I spoke to a colleague who was who had been an international arbiter, and he said that very often in an arbitration case they have to deal with common law, with civil law, with Chinese law, with Japanese law, with Singapore law at the same time, because the arbiters come from a different background and the parties come from a different background, and then the contracts have assigned have been drawn up according to yet another legal system. So the interaction between legal systems and the is more and more important. The same goes for what is called product change. Products that are being made in one country and then transported to another country and yet to another country and yet to another country. And each country has its own state legal system, and so the product change has to go through different legal systems. Now, one of the important issues in these plural legal contexts is that each legal system operates with different legal concepts, and it is of vital importance to understand these different legal concepts and to see how they match or do not match amongst each other. And here, I think empirical legal studies help understand what the different legal concepts are and how they differ. And I've done research in Minangkabau where the adult concepts of property are completely different from the state and former colonial notions of individual ownership, and that has led and still is leading to difficult issues of expropriation and misunderstanding. Empirical legal studies also help understand how people navigate the legal systems. Very often there is a choice between one or the other, and empirical legal studies help understand why people opt for one or for the other. It also helps understand who profits and who loses out within one or the other context, a legal context. It also helps understand which legal system may be dominant and in which practices. the notion that the state legal system is always the dominant one is, of course, deeply flawed. It has been deeply flawed, and it still is. And in certain issues, and Stijn Stijn van Huis has done marvelous research on marriage, where he showed that the dominance of the state legal system is not self-evident. So I guess that is basically an outline of how of what legal practice is and how empirical legal studies may help may help to improve or to understand why lawyers and the legal practice is how it is. I think one of the important lessons of this or important consequences is that it's extremely important for lawyers to have some understanding of social sciences. And at the University of Rotterdam, Erasmus University of Rotterdam, where I used to teach, there was a lot of attention to social sciences and to economics also, but also social sciences in the legal training, because lawyers have so often to do with knowledge that is created by within social sciences, and if they don't have an inkling of what social sciences does, then they may not be able to use the knowledge produced by them properly. But also the social sciences should have an understanding of how law operates and how lawyers operate, because only then can there be of any help and can there be any mutual advantage. So I'll stop here. I hope this helps something. Thank you.
Thank you, Professor Kebet. Very interesting. One thing that I highlight is legal practice is different with empirical legal studies. The empirical legal studies should contribute to legal practice, and important for a lawyer to have knowledge about regarding social science, which yes, I do agree about that. Thank you once again, Professor Kebet, and all the panelists. We already have some questions. First, I think first two questions I will give to Mr. Iron from BINUS and Mr. Siddhartha, also from BINUS, and we still have a couple of panel participants who want to have the answer and questions. And one is Gregorius Sri Nur Haryanto. I don't know from what institutions. Maybe you can, what was it? You can introduce yourself and your institutions prior to questions to the panelists. First to Mr. Iron.
Okay, thank you very much for Miss Vidya. First of the slide from Prof. Adrian, is my voice sound clear?
Yes, it's clear.
Okay.
Clear.
Okay. I interest with the statement, with the statement in the first slide, the impossibility of justice without the empirical knowledge. Okay. In my opinion, I also maybe the practice or the academic in law who are not not only as a normative as my basis, also social or empirical or philosophical based on my standard is also support to me to do the practice in my text or my analysis and my research or what else. I would like to asking regarding how the normative aspect could replace, Prof. Ardian, normative aspect could replace with the empirical aspect. How? I mean, we know Indonesia is there is some regulation and maybe some the authority of law always use the normative in the pasal-pasal dalam in peraturan perundang-undangan, and in my part I am the lecturer who concerned with the labor of law. So I always practice without the normative, Prof. Ardian. Somehow we met the settlement with the empirical aspect without normative aspect. And for the first question, I would like get the underline with you as a professor or as a empirical science in law, and perhaps it could be for me become a value and to do some practical. That is the first question. And the second question is, the law normative always be a legal certainty, kepastian hukum. Yeah. That we know, somehow in the practical we can make justice. This is have a correlation with the first question. In the some practice, we can make justice without the normative normative aspect. How do you can also make the underline with that statement of my second question? Thank you, Prof. Adrian. Really regard to your answer. Thank you very much.
Okay, thank you, Mr. Iron. Next, Mr. Siddhartha.
Hello?
Yeah. Yeah, Pak Siddhartha, silakan.
I just want to ask Adrian. Adrian, do you believe that someday that the task of a judge can be replaced by artificial intelligence? And to Mark, I want to ask about the comments, as you mentioned, you quote Oliver Wendell Holmes, that the life of the law has not been logic and has been experience, and you said that the prophecy of what the law will do is the law itself. Many people criticize the legal positivism paradigm by saying that judges tend to decide cases by relying solely on the legislation. However, in fact, if judges adhere to the finding force of precedent as practiced in the common law system, of course, their decision will be as rigid as a decision that follow the legislation. What do you think about this? Thank you.
Thank you, Mr. Siddhartha. One other question is from Gregorio Sri Nur Haryanto.
Okay. Thank you
Yes.
very much, the moderator. Good evening or good morning for the speaker. Yeah, I would like to deliver a question to Professor Adrian and also Professor Mark, yeah, relating the topic to discussion this evening, yeah, particularly about legal practice and legal policy nowadays. Yeah. I think almost all the countries in around the world, yeah, always referring to the empirical legal research because without using it, yeah, I think it is impossible. A government of state, yeah, particularly the three branches of the power of state, yeah, including an executive or governments, yeah, and then judicial system and also legislative, yeah. Never use the empirical legal research because without that, I think it is impossible for them to face the challenge situation, yeah, in the society in the generally, and especially to Professor Mark, yeah. Why I said as I said before. Referring to the Cardoso, yeah, as a judge in the United States too, he has ever said that for running his duty as a judge is not only based on his belief, yeah, but he always referring to the values in the society in the generally, yeah. I need a comment. It is part of the empirical legal research too relating this one or not? And secondly, to Professor Mark, yeah, because just now based on your curriculum vitae, you stated by the moderator, you have ever become the special supervisor in human rights court in East Timor at the time, yeah, after the ballot in East Timor, yeah. Is it the judiciary system and the implementation of human rights law over there is really justice and fair or not? I hope I get a comment from you. And the last question for Professor Kibet, yeah, referring your experience, making a research in Minangkabau, etc. Yeah, to be honest, according my opinion, yeah, because my background is international law and human rights law, yeah. I'm a lecturer of international law and human rights law in Faculty of Law at Majaya Yogyakarta University, yeah. Referring to the hukum adat, yeah, or adat law in Minangkabau, it is fully, yeah, based on experience. As the typically of the hukum adat, usually always referring to the repeated action in the certain period time continuously, and the most important thing, and then there is an opinio juris necessitatis, yeah. There is the conviction from the society, yeah, to bind and implementing the adat law. Thank you very much. I want to get your comment relating my question. Thank you, moderator.
Okay. Thank you. Thank you for all the participants to the questions session 1. To the panelists, you can answer the questions. Start with, I think, with Professor Adrian first, and then to Professor Mark, and then to Professor Kevin.
Yes, well, thank you for these questions, which are really challenging and would allow me to give another presentation, but I won't. I'll try to be short. The first point mentioned by Iron, which is really the question whether you can actually, whether you can replace the empirical aspect. Well, I think we agree. I think you can't. I think you always need empirical knowledge. I think Ivo Kebet made a very clear, gave a very good clarification why you can't leave out empirical knowledge at all. Is indeed practice always like that? No, it's not. Unfortunately, this is what we saw in Germany in the 19th century, and which we've seen every now and again in other places, including Indonesia, is that lawyers tend to look only at the legal texts without checking anymore whether the basis of these legal texts still find any linkage with reality. So society changes. If you still, if you take, for instance, the civil code in Indonesia, which was basically designed somewhere in the 19th century, at a time when society was completely different, when many inventions had not been made. And of course, we all know that judges need to keep up with this, and that the legal system needs to keep up with developments in society, and that it's impossible to do this by legislation only. So this is where an important task lies for legal actors, judges, but also others, in keeping the legislation in tune also with societal developments. So I fully agree with Pa Iron that it's impossible to do law without taking that into account. And that also that links up with your second point about legal certainty. I think it's I absolutely agree here with you again. I think that it's a misconception, it's a wrong idea that you would need a legist interpretation or a formalist interpretation that would promote legal certainty, because it's false legal certainty that it promotes, because it produces results supposedly on the basis of a law that links up with the conditions in society, but in fact not linking up with them anymore. A very good example is, for instance, a case from the Netherlands where a debt that could not be repaid before the First World War was then actually was supposed to be repaid after the First World War, when incredible inflation had taken place in Germany, so the debt was not worth anything anymore. And there was a claim at the Dutch court where the claimant said, look, we need to take into account the drop in value of the money. And where the judge said, no, it says, it's very clear. There's no reason to do that. I mean, a mark is a mark, rupiah adalah rupiah. So meaning that the debt had no worth at all anymore. Well, this is generally considered, this is very much the way of interpreting the law without taking into account societal developments. And that is something that should not be done. Then Pak Siddhartha, I think for, yeah.
Thank you.
You're welcome. Then for Siddhartha, the question about artificial intelligence. Yes, for certain cases, it can replace judges. The very simple cases, the cases which are more administrative in nature, the more complex they become, the harder it becomes. And the question then becomes also an ethical one. Do you think that artificial intelligence can think as a human? And can it actually, or as a perfected human? Well, here we get into an area of speculation where I'm absolutely not qualified to say anything about. I do think that this carries with it very important ethical questions, and I would be very hesitant to do this. I can tell you that if there's one country in which they are considering ideas like this, it's China. I'm now supervising also a PhD, somebody looking at smart courts in China. But even in China, so far, the real decisions are still taken by human beings and not by artificial intelligence. So it's perhaps not going as fast in all respects as we sometimes think. And then very briefly to Pau Gregorius, but Mark will say will say more about it and Quebec. What I think is really important, I find the idea of values in society, which should be taken into account. I mentioned that, but Ibu Quebec really made a very important point here, I think, because the values in society may be completely different from the values in the state legal system. And I also think that that this is a case where you could speak of folk law or living law or whatever you want to call it, you should understand that this is really, really important, and that without knowledge of such systems, you will either completely lose your legitimacy, produce outcomes, decisions which are unjust in the eyes of those seeking justice. So there's all kinds of problems related with pursuing such a course as a judge. So I think this is really important to take into account. That was it for me.
Okay, thank you. Next, Professor Mark.
Thank you. And again, those are big questions, and I'm sure I won't do justice to them. But first of all, Professor Siddhartha's question about whether courts that are bound to follow precedent would, rather than being better able to adapt the law to the needs of society at the moment, would in fact be compelled to act more rigidly, whether precedent would constrain the decisions of judges further than they are constrained by legislation, and thereby have the effect of preventing courts from ensuring that the law reflects contemporary needs and values. The notion that I think it's just the opposite, actually. If I'm often amazed at how little the legal rules that judges are called on to apply in Indonesia actually guide the court's decision. I'm currently working on, been asked to provide advice to a court in the US that is trying a case that is based on Indonesian law, specifically on Article 1365 of the Civil Code, what constitutes a perbuatan melawan hukum. And if the formal statements of what that means provide so little guidance that the US judge could decide the case any way he wished. And if I simply tell the judge, well, here's what the statute says, and here's what Professor Rosa Agustina has said about it, they're going to say, well, that doesn't, you haven't helped me a bit. You've got to give me a little bit more, you've got to give me a little bit more information about what this means. And so what I've tried to do, and this is very difficult to do, is to go out and see how courts have actually applied this rule. And it's hard to do because while there are millions of cases up on the website of the Mahkamah Agung, there's simply no way of finding the case that addresses the kind of situation that the court in the US is got to decide. And so to give them any sort of guidance as to, well, here's how an Indonesian court might approach that question. So it's the notion that requiring courts to comply with decisions of other courts addressing the same issue is going to give them greater discretion, or they're more constrained if they simply apply the statute, I think is simply not correct. That said, with respect, the other question asks, so my response to Professor Siddhartha's question seems to say that if courts are required to comply with precedent, then their decisions are going to be tightly constrained, and there's no room for them to then make the law to consider what the needs and values of contemporary society is, and therefore make the law consistent with those needs and values. But that's also not the case. Professor Keeb mentioned the fact that social scientists have to deal with ambiguity and lawyers have to deal with certainty. Both have to deal with a great deal of uncertainty. If you ask a lawyer what the answer to some legal question is, the answer from any good lawyer is going to be, well, that depends. And there are arguments. The law is, what we try to teach our students is the law doesn't have answers, it has arguments. And what you have to do is use the law, or use the decisions, the sources, the means of analyzing those sources that are available, and try to construct an argument that reaches a solution that is, depending on where you sit in the process, reaches a solution that serves the needs of your client, or if you're a judge, that serves the needs and values of the people who the decision is going to affect. So the law is simply not capable of doing what we think it does, which is prescribing answers to questions that judges are simply compelled to answer. I mean, it does in some cases. There are lots of cases where there's no room for dispute as to how existing sources should be applied in this particular circumstance, but those are not the important cases. And in areas where it really matters, there's a great deal of flexibility in every type of legal system. And finally, the last question related to the trials before the Ad hoc Human Rights Court for East Timor, and that is a really complicated question. I think those trials were problematic in all sorts of ways, and for reasons that have been widely discussed. One point that does not really address the question, but sort of serves my purpose here, is that I haven't written a lot about those trials, but I did write one article, and the point of that article, what I think I demonstrated, is that the decisions that were reached by the various panels that decided the cases was very much influenced by who happened to be assigned to that particular panel. That the panels with these judges, with a particular group of judges, consistently acquitted, and the panels with another group of judges tended to convict. So and you can say, well, that's just coincidental, but the evidence in the cases was very, very similar. The same witnesses testified over and over again, and the charges were closely similar. It's hard to explain the different outcomes in the different cases based on the law and the facts. What appears to be driving the decisions is who it was that was called upon to make the decision, which is one of the basic insights of this whole this legal philosophy referred to as legal realism. You can't separate legal decision making from the decision maker. You can't separate interpretation from the interpretation of legal texts from the person, the values, the experience of the individual who's called upon to make that interpretation. So I'll now pass it to Professor Keeb.
Professor?
Yeah, it's interesting to see that in international law, there is more and more acknowledgement that local forms of law are important and have to be recognized. But ADAT, of course, the English translation is of ADAT is customary law. And customary is a bit of a misnomer because it suggests that people just do what ADAT prescribes, and that is, of course, not the case, as it is not the case in any legal system. So ADAT law is something that some people even acknowledge and support, but there's also a lot of criticism about it. And ADAT changes. It has been subject to change. It changes in some sense in response to state law, but in other respects also to economic change and so forth. And the changes can not only be found in court decisions, but they occur locally, and the changes that occur locally may be different from what the courts, how the courts interpret ADAT. So there may be versions of ADAT as they are practiced in court, and there may be versions of ADAT as they are practiced in local interaction and relationships. Thank you.
Thank you. It's getting late night in Jakarta, but we still have a couple questions. First, Mr. Haikal, Muhammad Haikal, our bachelor students want to ask something to the panelists. And then second, Mrs. Teresia Dia. And last for this session, from Aceh, I think his name is Saleh Fasel from Aceh.
Saleh Shafi. I just wrote my questions.
Yeah.
I think I don't need to speak orally. Just read my question through the chat room. It's okay for me. Thank you.
Okay. First, Mr. Haikal.
Yes, Miss.
Yeah.
So I have a question for Professor Beckman. As you said before, ambiguity is one of the core of the social sciences. And as it's impossible to gain definite and conclusive resolution from qualitative research, such as participant observation and structured interviews, my question is, how can ambiguity that resulted from empirical legal studies be useful in a court, since ambiguity implies that the results are not definite and conclusive and may lead to multiple interpretations?
Thank you. And then Ms. Teresia Dia. Miss Dia. I think the question. Okay. Yes.
Okay. First of all, I would like to say thank you to Professors Adrian, Mark Kamek, and Professor Kbet von Beckman for your wonderful presentations. I have one question for Ibu Kbet, because in Mark's presentation, I think he made quite a thought-provoking statement by saying that all law is actually empirical. Well, at least in the US context. So I have a question, because in Indonesia, judges often view themselves as the corong undang-undang. So in this case, is this also your experience regarding disputes or cases at the pengadilan negeri that involve adat or Islamic elements, for instance? Are the judges also act as the corong undang-undang, or they themselves were or are rather relaxed in translating the law in the books? Thank you.
Thank you. I think one question from Mr. Sabto Hermawan. Is it Mr. Sabto Hermawan here? From UNS Solo? Or already leave the forum? Okay, waiting for Mr. Sabto Hermawan. I think one is Riyad from Brawijaya.
Yes.
Yes.
Thank you. Okay, thank you, moderator. I have a question to Mr. Professor Adrian from Leiden. Yeah, I have sent email for you maybe last month. Sorry. So I need your opinion about how social legal work to replace the status quo of institution by law to make social justice and then environmental wisdom come true. Yeah, I'm a postgraduate student in University of Brawijaya. Thank you, Professor Adrian.
Okay, thank you for the question. I think we refer first from Professor Kebet and then Adrian and then last Professor Mark. Is it okay?
Okay, so about ambiguity, maybe I was not clear enough. I was too short on this. Of course, law is always dealing with ambiguity, but the purpose and the aim is to bring something to an end, to make a clear decision, to come to come to some degree of certainty. And now, because a law is a process, of course, the certainty only lasts as long as it lasts. But looking for certainty and looking for concrete solutions is at the core of law, I would say, even with all the ambiguity that they have to deal with. And it is a task of lawyers and of courts to bring an end to the ambiguity and to create some degree of certainty. That is not the main purpose of social sciences. And so I'm saying they can be, the result of research can be that there is ambiguity. Now, if that is the case, they have to present that to courts, and the courts have to, and lawyers and judges have to deal with that. That is a task of lawyers and not of social scientists. And that's why I said there needs to be a degree of translation. The ambiguity, the ambiguous results have to be translated to make them useful for lawyers and courts and legislators and so forth. Now, of course, to Teresia's question, all law is empirical. Well, yes, law is one kind of empirical situation or empirical context, and there are many more. And law, the actors in the legal system have to deal with the other parts of the empirical world. Now, in the legal contexts, in context of courts, in context of legislation, in context of state administration, so Adat and Islamic terms have to be somehow translated to fit into that system. But the other way around is the same happens. State law has to be translated into context of Adat, into context of Islam. And so there is a reverse relationship within and among the various legal systems. And and the institutions that deal with these legal systems. Thank you.
Thank you. Then Professor Adrian, yes.
Yeah. Okay. Thank you for these questions. The question from Riyadh. How can social legal studies contribute to social justice and environmental wisdom?
Yes, thank you.
Well, I think they can do that. They can do so at different levels, and actually many of these forums were already mentioned during the presentations of all three of us, actually. So if you know, if as a legislator you need to produce new legislation, you want to be informed well, and one of the things you want to be informed well about is how particular measures will work out in practice, what that will mean for issues like social justice. You also need to, of course, define what you mean by social justice, but also environmental effects, also environmental wisdom. How do certain measures relate to practices by people in a particular place? I think that plays at the level of the legislator, but also at the level of the implementation of policies, of policy making, and the implementation of policies by administrative agencies, and also at the level of judges taking decisions. Now, I'll give you one example. This recent research on plantations, oil palm plantations by Tanya Lee, which sketches a devastating picture of the effects plantations generally, but particularly oil palm plantations, have on social life and on the environment in Kalimantan. Knowledge of such studies is really quite important at all these levels. And then for the level of the judge, I still want to add that because Indonesia now has a constitution with a complete set of human rights in it, including social economic rights, the judge actually has more opportunities to do something with this knowledge than before. So because there is a right to a proper environment, you can actually take into account studies like this and knowledge generated by studies like this in your decision. And this is, I think, something also that students should be aware of and should be taught in law school in order to become good lawyers, good jurists. I also wanted to add to the point of Ibuke Bed made, there is a wonderful book by Mitchell Lesser, in which he discusses how judges take decisions. And it's a book comparing the French Supreme Court with the American Supreme Court and the European Court of Justice. And in particular, the French model, which when you look at it from the outside, looks like a very mechanistic model. He shows that it's very open and that it's all kinds of information that they take into account when coming to a decision. And the reason I'm making the point is that it shows the ambiguity and the incredible amount of the ambiguity judges have to deal with in difficult cases. Of course, there's common cases where things are fairly clear cut, but in particularly important cases, their judges need to be inventive. And we're seeing lots of things happening here in Europe, also in the field of environmental law. The German Constitutional Court taking a really important decision. They're overriding policy makers. We have seen the same in the Netherlands with cases. So a lot's going on in this respect. And if you don't tell your students how this works, then they will be at a disadvantage and they will not be able to perform well, I think. Finally, Shafi also asked the question about how law is a social practice based on a normative text. Well, there is a normative text, but in order to understand the normative text, of course, you need to look at the world around you. If the legal text speaks of a house, you need to define what a house is, and therefore you will be looking at explanations people give in general life about what a house is before you can even start to make sense of the concept. Now, a lot of that will find its way into legal texts, and at some point there will be a lot of clarity. But when the world changes and houses change, you know, new apartments are built, then you will have to adjust your schemes. So there is a constant going between facts, between social developments in the real world and the law. So that was a point I still wanted to add. Thank you.
Thank you. Last, Professor Mark.
I don't know if there was a question that was directly addressed to me, but I would like to make a sort of point of clarification. When I'm not suggesting that in the US there's not something called social science research about law or empirical research about law that's different than what lawyers do. There very definitely is. I'm a member of the Law and Society Association, which distinguishes itself from what lawyers do. My point is simply that the things that lawyers look at, and lawyers have narrow, specific, practical ends that are very different from social scientists, but the things that lawyers study are also empirical facts. It's a very narrow set of those empirical manifestations of law, but they're not something that is, they're not metaphysical things that exist in some ideal form, because there is no such thing. Law is what happens in courts, what happens in lawyers' offices, what happens in insurance company settlement disputes. That's the only thing there is. And as I say, lawyers carve out a very narrow set of these empirical facts, and that's what we focus on for particular goals. And the relevance of this to this discussion is also fairly narrow, I think. And what my what I would urge people to do is to go out and see, just look at what Indonesian courts are doing, which in most legal scholarship in Indonesia plays a very small role in the way the legal system is studied. And there's lots to be learned, I think, in terms of in terms of what kinds of values are being reflected, in terms of the extent to which the legal system successfully, which I think everybody would agree, and this is an aspect of that notion of legal certainty that the law seeks to achieve, the extent to which courts are able to achieve coherence in the way statutes are interpreted. Just lots and lots of interesting things to learn if we expand our understanding of what the law is somewhat, and this in a very small way, to just go out and see what courts are doing.
Thank you for the panelists. Very nice discussions. We have still several questions, but I'm afraid Professor Cabot have to go, and we have to end this Q&A questions and discussions. But for the participants, the link for absence and the link for panelist material can see in the chat room. And I think Professor Cabot, can I have like 2 minutes to closing statement from you, and then to Professor Mark, and then to Adrian's, please?
Okay, thank you. Well, I have very little to add, and I think it was a very interesting panel and interesting questions. There's lots more to say. And there's lots more to say about comparing different legal systems, for instance, the US and Indonesia and the Netherlands that we have seen today. It would be worthwhile to go deeper into that, but there's no time for that now, maybe for another occasion. So I thank you for letting me participate in this, and all the best. Thank you.
Thank you. Such an honor to have you in this event. Professor Mark?
I think I pretty much said what I would have said in answer to that question just a minute ago. That I'm not trying to convince anybody to adopt my view of what the law is, because as I said, in some sense, answering the question of what the law really is not that helpful. But I think everybody, we're all in agreement here, and I don't think we need to really work that hard to convince the audience as well that there are lots of ways that we can better understand this practice that we're all engaged in by simply broadening the scope of the things that we examine. So I'll leave it at that. Thank you.
Okay, thank you. Last, Professor Adrian.
Yes, well, like the other speakers, I'm grateful that I was invited for this session. I thought it was quite fruitful. I thought there were a number of good questions and a lot of interesting, important things that were being discussed. The one thing I want to convey to all attendants, and particularly to students, is to be always critical and never to accept anything as this is the law, that's how it is. There always is a reason to look critically at the law and to consider whether a particular decision is the right one, or whether what your professor says is correct or not. Be critical of your professors as well. They are not like sources or fountainheads of knowledge. They've thought about things, but this thinking should invite critical thoughts from students. And I think in that way, the Indonesian legal system can have a bright future. And I look forward to contribute a little bit to that future by also being contradicted by Indonesian students. So thank you very much.
Thank you. Thank you, Professor, participant, Professor and panelists and the participant for these sessions. I'm sorry that we are running out of time, but we still have a lot of questions. Maybe we can arrange next sessions with deeper issues, maybe for specific audience, so we can ask specific things. Thank you, and I give back this floor to the Master of Ceremony.
Thank you, Ms. Vidya Prahasachita. And before we end this webinar, we would like to give certificate to all of the speakers, and it will be presented by Mr. Ahmad Sofian as Head of Business Law Department at the Business University. Mr. Ahmad Sofian, the floor is yours.
Yeah, thank you very much for the all speakers and then moderator, and also the smart question from all, or not from all, but from the some participants. Thank you very much. And I think we will continue for the next international webinar. And in this time, I will give appreciation for the all speakers with the certification of appreciation from the business law. The first to Prof. Adrian Bednar from the Leiden University. We can give applause, virtual applause, I think, yeah, to Prof. Adrian Bednar. And then, yeah, the next certificate is for Mark Kamek from the Southwestern Law School. We can give virtual applause to Prof. Mark Kamek. And the last, the certificate to Prof. Kibet von Bender Beckman from the Max Planck Institute Halle. Yeah. Can we give a big applause to all speakers? And then thank you very much for the MC Kalisa Dia for lead this international webinar.
Thank you, Mr. Sofian. And now we'll have a photo session. So all of the participants, we would like you to turn your camera on. And for Sharika, can take our photos.
Hey everyone, first page. Second page. Okay, that's it. Thank you.
Thank you, Sharika. And I would like to thank you for all the participants, of all the speakers, Prof. Adrian, Prof. Mark, and Prof. Kibet, lecturers, organizer, and all the participants. Hopefully, the material from this webinar can be tools for us as a motivation to learn more towards legal research field and a provision for all of our knowledge in the future. And hopefully, we can meet again on another occasion. Finally, I would like to say thank you, Professor, to all parties that already participated on this webinar. And I would like to apologize if there are any words that are not pleasing. And to end this webinar, I would like to read a quote from a famous author, namely Dr. Seuss. It says that the more that you read, the more things you will know. The more that you learn, the more places you'll go. My name is Kalisa Dia. Thank you and see you again.
Thank you very much.